Very warm welcome to my business laws channel. Today, friends, I'm going to take up chapter number 9, which is entitled Quasi Contracts. You all have studied classification of contract in the very first chapter. We can classify the contracts on the basis of creation into 4 categories. First was express contract, then implied contract, quasi or constructive contracts, and the last was e-contract or high-tech contract or digital contract. So quasi contracts, it is one of the chapters under the Indian Contract Act, which is chapter number 9. So in today's videos class, I'll be teaching you what is the meaning of quasi contracts, and then after that, what are the different types or kinds of quasi contractual obligations. So in some situations, there is neither agreement nor consensus ad idem between the parties, but yet the law imposes some obligations on one party and confers the rights in favor of others. So you all know, friends, that agreement is a sum total of offer plus acceptance, and contract is equal to agreement plus enforceability. But there are certain cases where we do find there is no offer, there is no acceptance. Still, there are certain obligations which are thrown by the law on one person, and then there are certain rights which are provided to the other person. So these obligations created by the law, they are known as quasi contracts. For example, friends, finder of goods. Finder of goods is under an obligation to restore the goods to the real owner if the real owner is traceable. And it becomes his duty. Whose duty? Finder of goods. That he must take the reasonable care of the goods bailed, of the goods which he has found. Now, these obligations have been termed as certain relations resembling those created by the contracts under Indian law, and they are known as quasi or constructive contracts under the English law. Now, law of quasi contracts is also known as the law of restitution. So you all know, friends, the principle of restitution. The principle provides that if any person has derived any benefit under the agreement, or there is no agreement, if any benefit has been derived, it becomes his duty. He must return this benefit to the other person from whom the benefit has been derived. This is the meaning of the term law of restitution. So Section 73 of the Act provides that when an obligation resembling those created by a contract has been incurred and has not been discharged, any person injured by the failure to discharge it is entitled to receive the same compensation from the party in default, as if such person has contracted to discharge it. So, friends, whatever are the consequences of contract, the same consequences will be there of the quasi contracts. Now, quasi contracts are based upon the principle of unjust enrichment, which provides nobody is allowed to enrich himself at the expense of another. Meaning thereby, if any person has derived any benefit under the agreement, under this obligation, then it becomes his duty. He must return this benefit to the other person from whom the benefit has been derived. Moses versus McFarlane is a very, very important case law regarding this, where the obligation was there and the money was refunded to the party. Obligation was discharged, and then later on the money was refunded to the party. So moving ahead, friends, now I'll take up kinds of quasi contracts. There are 5 types of quasi contracts which have been provided under sections 68 to 72 of the ICA 1872. First one is, friends, supply of necessaries to incompetent persons. Section 68. Second is payment by an interested person. Section is 69. Third is obligations of a person enjoying the benefit of non-gratuitous act. Section is 70. 70. Fourth is responsibility of finder of goods. Section is 71. And the last one is money paid or goods delivered by mistake or under coercion. Section is 72. Very first point, supply of necessaries to incompetent persons. You all know, friends, this is not a new point for all of you. You have already studied under the chapter competency of the parties to contract. Minus liability for necessaries or necessities. Section 68 lays down if a person incapable of entering into a contract or anyone whom he is legally bound to support is supplied by another person with the necessaries suited to his condition in life. The person who has furnished such supplies is entitled to be reimbursed from the property of such incapable person. So friends, already you have said it. Necessities is not confined to roti, kapda and makan. Whatever suits to the condition of such person. Okay, so the money will be reimbursed from the property of such incapable person. An incapable person could be minor person, person of unsound mind, or disqualified persons. Few examples of necessities have been given here: basic needs, water, shelter, and clothing. Another example is A supplies B, a lunatic, person of unsound mind, with necessaries suitable to his condition in life, is entitled to be reimbursed from B's property. Nothing new, you all know these points. A supplies the wife and children of B, a lunatic, with necessaries suitable to their condition in life, is entitled to be reimbursed from B's property. Now, second point is payment made by an interested person. Section 69 provides a person who is interested in the payment of money which another is bound by law to pay, and who therefore pays it, is entitled to be reimbursed by the other. Any person who is interested in the payment makes a payment on behalf of someone, then it becomes a duty of the person on whose behalf the money has been paid. He must reimburse, he must refund this money to the person who has paid. So, but there are some conditions which must be satisfied for the application of Section 69. And now, friends, I'll take up all these conditions and I will explain. The plaintiff must be interested in making the payment. So, there are two parties involved. One is the defendant, second is the plaintiff. Plaintiff must be interested in making the payment. The plaintiff himself should not be bound to pay. The defendant should have been legally bound by law to pay. The payment should have been made to another person and not to himself, not to the department. Say, for example, Gus, A has given his land on lease basis to B person. A has to pay land revenues to the government, but he commits default. And now B knows that if he doesn't make the payment of land revenues, A doesn't make the payment of land revenues, then his lease will be cancelled. Now B has interest in the payment. So B makes a payment on behalf of A. Now B must be reimbursed by A person. Now why B has made the payment? B has made the payment because he has his own interest in the payment. And A was bound to make this payment by the law. So friends, B should be reimbursed by the law under this quasi contract under Section 69. But remember, friends, if person has no interest in the payment, say the lease agreement is between A and B, A has not made the payment to the government, now C makes a payment, then C will not be reimbursed because C has no interest in the payment. So all these conditions must be satisfied. Payment must be made by one person to another person and not to himself. So there is a case law regarding this. In all these case laws, Secretary of State for India versus Fernandez, Brooks Wharf versus Goodman Brothers, Tulsa Kumar versus Jageshwar Prasad. In all these cases, friends, the money was paid. In the very first case, the money was given by the Forest Department. So revenues and forest department are the departments of the government. If forest department makes a payment to the revenue department, it means the payment is going to be made to the government. So here the payment will not be reimbursed. And in the second and the third case laws, which are before you here on the screen, in these two cases, the person made the payment. Why he made the payment? Because he had his own interest in the payment, and he was reimbursed this payment under section 69. Now moving ahead, friends, the next one is obligation of a person enjoying benefit of non-gratuitous act. What is the meaning of non-gratuitous act? Let me tell you, friends. Gratuitous is, without reward or consideration. And non-gratuitous is with reward or consideration. Non-gratuitous. Obligation of a person enjoying benefit of non-gratuitous act. Act was non-gratuitous. It was undertaken with consideration. Then any person who has got the benefit of that, he must pay for that. So section 60 lays down when a person lawfully does anything for another person or delivers anything to him, not intending to do so gratuitously, because he is not doing without consideration or without reward, and such other person enjoys the benefit thereof. The latter is bound to make compensation to the former in respect of or to restore the things so done or delivered. Examples are before you, friends, and they'll give you better clarification. A tradesman leaves goods at B's house by mistake. Now B thinks the goods are his own goods. Now he's bound to pay A for them. He consumes them or uses them. Okay, so he's got the benefit of the goods. Then it becomes his duty. He must pay for that. A saved B's property from fire. A is not entitled to claim compensation from B if the circumstances show that he intended to act gratuitously. A saves B's property from fire, and he tells everybody gathered over there, oh, look, I'm going to risk my life in order to save this property from fire, but I must be given the consideration. Then, friends, B's duty is that he must pay the reasonable amount to A person. I hope you must be clear about all these points, and if you have any doubt, friends, then you can always write in the comment section. But for section 70, there are certain conditions which must be satisfied. Services should have been rendered lawfully. Services should have been legal services and not illegal services. If a person commits a murder of another, that will not be covered here under section 70. The person rendering the services should not have intended to do gratuitously. He should have performed these services, he should have rendered these services without being requested by another. And also, he should have rendered the services with the intention of getting reward or consideration. The person for whom the act is done is not bound to pay unless he had the choice to reject the services. If he has rejected the services, he has not got the benefit of that, then he is not bound to pay for the services. Services should have been rendered without any request. That B person never told A, you come and render these services. Services must have been rendered on voluntary basis. The defendant must have enjoyed or derived a direct benefit from the payment or services. So whatever services have been rendered, of course, we are presuming legal services, and the other person must have derived the benefit out of those services. Then only he will make the payment. So moving ahead, friends, the next point is responsibility of finder of goods. Who is finder of goods? Any person who finds goods lying anywhere on the road or on the street, and he takes the goods into his own custody, then he will be known as a finder of goods. So friends, section 71 provides a person who finds goods belonging to another and takes them into his own custody is subject to the same responsibility as a bailee. So bailee, friends, we use this term under the context of bailment. Finder of goods position is that of a bailee. Bailer is a person who delivers the goods, and bailee is a person to whom the goods are delivered. But friends, there are certain obligations or duties which are to be performed by the finder of goods. Take reasonable care of the goods as a man of ordinary man would take care of his own goods. As the owner takes the care of his own goods, in the similar way, the finder of goods should take the care of goods found. He should also take all necessary steps to trace the owner. It is his prime duty. After he has found the goods, he should look for the real owner and not to make use of those goods. He should not use the goods. He should just possess the goods, to return the goods to the owner if found. If the owner is traceable, that is, we are presuming he has tried to find out the real owner, and a real owner has been traced, then it becomes his obligation. He must return those goods to the real owner. Now, there are certain rights which are enjoyed by the finder of goods. And these rights are: keep possession of the goods as against everyone except the true owner. In the eyes of law, if the owner is traceable, then the finder should return the goods to the owner. Otherwise, he has a right to keep the possession of goods as against everyone except the true owner. He has a right to claim expenses incurred for maintenance of goods. If certain expenses have been incurred by him in order to maintain the goods, then he must be reimbursed by the owner. To sue the owner for reward. Sometimes, when article is lost, when the goods are lost, the owner makes, gives advertisement. Lost. The description of goods is also given, and then reward is announced. If a reward has been announced on the lost goods, then it becomes the duty of the owner. He must, give this reward to the finder of goods. Or finder of goods has the right to sue the owner for reward. Another right is, friends, to exercise right of lien for expenses or rewards, but cannot sue the owner for these expenses. He has a right to retain the goods. Say he has found the goods. Goods were not in working condition. So he incurred certain expenses to put the items in the working condition. And now the real owner becomes traceable. Then it becomes his duty. All the expenses which he has incurred, say he has incurred to the tune of 200 rupees, then the owner must pay 200 rupees to the finder. If owner doesn't pay, finder has the right of lien. He has a right to retain the goods till his expenses are paid. And now the last right about which I'm going to talk, friends, that is the right to sell the goods. The finder has the right to sell the goods. In which cases? Where the owner is not traceable. The owner could not be found out. The item is perishable, say milk or fruits. Okay, and if the finder keeps them into his own custody, then with the expiry of time, the goods will get perished because they are of perishable nature. Then also he has the right, if he wants, he can sell them. And if the owner, refuses to pay the lawful charges, the charges which have been incurred by the finder of goods, the owner has refused to pay those charges. Then also, the finder of goods has the right to sell them. If the expenses incurred by the finder of goods, they amount to 2/3 of the value of goods found, then also the finder of goods has the right to sell those goods. Now the last point is money paid or goods delivered by mistake or under coercion. Now this point is discussed under section 72. Payment made which was not legally due. Payments made under mistake can be recovered, but under natural obligation cannot be recovered. So section 72 provides a person to whom the money has been paid or anything delivered by mistake or under coercion must repay or return it. Now, money paid under threat or of attachment of property or under protest on getting threat from the government that on failure to pay, the facility will be withdrawn. Friends, now mistake of law and mistake of fact. Before I take up this point, I would like to explain this fifth point with the help of examples. Say A and B owe rupees 10,000 to C. A has made the payment to C and B is unaware of this payment. B has also made the payment of 5,000 rupees to C. It means C has got double payment of 5,000 rupees from A as well as from B. Then it becomes his duty, C's duty. He must return one payment to A or B because money has been paid to him by mistake. Take the example of goods when they are, detained under coercion. Say A consignor of Delhi has consigned goods to B of Mumbai, consignee. The goods have reached from A to B through railway company. Now, railway company, when the goods reach at the point of destination, they tell the consignee person that you have to pay illegal amount of charges. Otherwise, the possession of the goods will not be given to you at the point of destination. So what consignee does? He pays the charges. So here also, the goods have been detained under coercion. He has paid the charges. He must be returned these charges. There's a case law here which provides that Section 72, did not draw any distinction between mistake of law and mistake of fact. Case law is Sales Tax Officer Binaras versus Kanhaiya Lal Mukand Lal Saraf. In this case, K had paid sales tax on his forward transactions under UP Sales Tax Act. Subsequently, the levy of Sales Tax Act was held to be ultra-vires. Ultra-vires. Ultra means beyond, vires means powers. Beyond the powers of the High Court of Allahabad. K claimed the refund of the tax under mistake of law under Section 72 of ICA 1872. Held, it was decided in the court of law that Section 72 did not draw the distinction between mistake of law and mistake of fact. And therefore, in this particular case, K was allowed. He was given the refund of the payment because it was beyond the powers. So friends, this is all about 5 obligations, quasi-contractual obligations types. So it is all from my side today. I hope you must have understood all the concepts. If any point is not clear to you, you can always write in the comment section. So friends, do subscribe to my channel if you have not subscribed yet. Okay, and do press on the bell icon so that you can get notifications of my future videos. Stay blessed always. Okay, friends. Goodbye. Bye-bye.